Hello, everyone. We're just going to give it a couple more minutes. I know it's 2:30 already, but we'll give it a couple more minutes. Hello, good afternoon. Um, Should we leave the door open for late? Oh, okay, thank you very much. Well, good afternoon and welcome. Welcome to the people online. There's a camera right at the back of the room. My name is Sarra Kay. We're looking forward to spending the next hour or so with you discussing the topic ad hoc arbitration using the LMAA terms for resolving disputes in shipping, trade, and offshore, and what, when, and how. We'll aim to finish after about an hour so that we can then have tea and chat. Let me introduce you first to our stellar panel. And if for some reason the mics, we're all talking away from the mics and you can't hear, would you please tell us? Because there's nothing more irritating than not actually being able to hear. Anyway, over to our stellar panel. We are super lucky to have Mr. Justice Andrew Baker of a Tuesday afternoon, commercial court judge and admiralty judge, various judgments of great import to your name. And I'm just going to mention one to demonstrate the extraordinary reach and respect of the English commercial court. And that's a case I think you spent most of last year on, the Danish tax case. I'm just going to read a quote in one of the press reports. Mr. Justice Baker has handed down a landmark, mammoth, 326-page judgment in what has been recognised as the most complex, high-value set of proceedings to come before the English Commercial Court. And the value of the claim was £1.4 billion. Is that about right? I tried to count up how many counsel were involved, and I actually lost count, and similarly in how many defendants there were. Anyway, we are very fortunate to have you, and we're looking forward to your keynote speech. Let me introduce Chris Moxon, who's right behind me. Chris. Chris is very unusual. He has, well, there might be other reasons, but I'm going to give you three. He has sat on three sides of the desk. He has been the private practitioner at Clyde & Co. for about 7 years, where he specialised in shipping and physical commodities. Then he moved to a P&I club, Standard Club, where he was claims director for P&I and FD&D disputes. And now he's in-house. He's now senior commercial counsel, senior legal counsel at RWE Supply and Trading, where he legals the company's freight and physical commodities desk. We are very fortunate to have you, Chris, because you are the ultimate user of the terms and your perspective is key. Jessica Neuberger, waves. We are particularly pleased to have Jess. She's from Eversheds. She's a partner in the construction and engineering group and London co-head of litigation and dispute management. It is no exaggeration to say she's a leading light in all forms of construction, engineering and operational disputes in the energy, built environment and infrastructure sectors. She advises on major projects all around the world in respect to risk management, dispute avoidance and dispute resolution through litigation, arbitration, adjudication, mediation. Jess's practice is particularly dominated by disputes in the energy sector, which involve multi-party contracts, and that's relevant to something we're going to come back to a little later. And Jess sits on the Council of the Society of Construction Law. William Cecil. William is one of our two panellists to have authored a leading maritime textbook. He heads the Haynes Boone London dispute resolution team. He specialises in particular in shipbuilding and complex marine construction and offshore energy disputes. And here it is. He's the co-author of the 5th edition of the Law of Shipbuilding Contracts. Sean O'Sullivan, KC, nickname SOS. I expect Sean is very familiar to quite a lot of you in the room. He's a widely acclaimed commercial silk who accepts arbitration appointments. He's a Deputy High Court judge. His practice spans the A to Z of disputes covering shipping, commodities, energy, insurance, reinsurance, offshore construction. And he was nominated again this year for the Legal 500 Shipping and Commodities Silk of the Year. And last but not least, Clare. Clare Ambrose is the second author on our panel. She's a barrister.
And Andrew.
Oh, sorry, got all. Should have told me after I'd said two. Okay, so most of the panel have co-authored something. I don't know what the books are. No, never mind. Back to Clare. Clare is a barrister and has been in practice at the commercial bar at, was it 20 Essex? For 25 years. She's now a full-time arbitrator and a full member of the LMAA. The book that Clare has co-authored is London Maritime Arbitration, currently working on the 5th edition, everyone. So get your wallets ready. And I can't not say this, but at the Bar Awards this year, Clare was crowned Arbitrator of the Year. So as you can see, our panellists have extensive experience in all forms of dispute resolution, but of course our focus is LMAA terms. Let me start with a very short overview. As many of you will know, arbitration disputes are either determined on an institutional basis or an ad hoc basis. Institutional arbitration is a dispute resolution process that is administered by a specific institution. For example, the ICC or the LCIA, and they administer in accordance with their own rules. So responsibility and oversight for things like appointment of arbitrators, publication of awards, and fixing fees structure for the arbitrators is down to the admin of the institution. Unlike ad hoc arbitration, this is a dispute resolution that's administered by the parties to the dispute. It's party-led, it's arbitrator-led. There may or may not be a set of terms, but for example, examples of ad hoc arbitration are LMAA terms and UNCATRAL. It's interesting to note that there is no consistency of approach within the maritime sector. Take, for example, the offshore energy space. There are different standard form contracts for different aspects of construction. And they typically all opt for arbitration rather than litigation, but then they all provide for different dispute resolution clauses. So the FIDIC suite of contracts, which is used for international offshore construction projects, provides for ICC. The logic forms, which are used for North Sea oil and gas disputes, provide for LCIA. The NEC forms, these are engineering contract forms used to facilitate good project management, offer court or court or arbitration, and then they leave it to the parties to decide. And then there's BIMCO. BIMCO has a standard suite of contracts for offshore projects, primarily in relation to hiring and supplying vessels. The ones I'm about to read out, which are known by their nickname, all provide for LMAA terms: supply time, wind time, heavy con, dismantle con, wreck stage. And BIMCO itself produces a standard dispute resolution clause. The default provision is English law LMAA terms. And then there's one other set of standard terms in the industry. They're called IMCA, and they're used for transport and installation works in offshore wind projects, and they too provide for LMAA terms. So as you can see, there's quite a mix. It's too ambitious for us to argue today, and it's not relevant today to say there should be some kind of alignment between all these forms. But what we are going to suggest is that the LMAA terms are standout leaders in the field, principally because the LMAA terms are tried and tested and very flexible. And we know that the LMAA terms are terms of preference for the marine industry as a whole when we compare our statistics with those of the institutions. And just to give you an example, last year there were over 3,000 appointments on LMAA terms, and we think that's conservative because we can't get all the data in. There were over 1,700 references and over 500 awards. And when you compare those stats with the stats published by the institutions, not just for marine but non-marine disputes, we are significant market leaders. Now, enough from me. Before we get into the weeds, I'm very, very pleased to welcome Mr. Justice Baker, who's going to give us a keynote speech.
Thank you very much, Sarah. I hope you can hear me because I have correctly worked out how to turn the microphone on. It may be that keynote speech is a slight overstatement. I see my function at today's session as really twofold. One is by presence in the room, and I hope the offering from time to time of a judicial perspective in relation to any questions that might arise from the floor to be an embodiment in person of the reality that is the support of the judiciary of England and Wales and the Commercial Court in particular for arbitration generally and London-seated arbitration in particular. The second is not so much to offer keynote thoughts of either great substance or, I suspect, novelty to most in the room, or I will admit thoughts tied specifically to the LMAA, because I must be even-handed across all institutions and sets of terms, but just to give a flavour of what that judicial support for the process and substance of arbitration looks like. In my view, there are two fundamental reasons why building on the world best, if you like, legal services infrastructure that exists in London for arbitration and maritime arbitration in particular, the English legal system provides very strong and particular support for arbitration as a method of resolving disputes. But the first is, if you like, substantive. Under the framework set by the 1996 Arbitration Act, recently tweaked but not changed massively by the 2025 Act, English law takes a stance in relation to arbitration in the modern world that is fundamentally driven by party autonomy, parties' entitlement to decide that they will arbitrate, not litigate, and coupled with that, a recognition that there is not now, if ever there had been in the past, there certainly is not now, any sort of one-size-fits-all way of delivering a fair result, which is fundamentally what any dispute resolution system is about, giving to the parties an answer arrived at the end of a fair dispute resolution process. The second reason is one of both history and, if you like, personnel. The fact is that the English Commercial Court at any given time is populated by a limited number of specialist judges from backgrounds in practice that will have included, for example, in my case, a practice at the English bar in which the single most important dispute resolution forum in which I practiced was London Arbitration, and probably in my own case, I would say London Arbitration on LMAA terms as it happens. In other words, you have senior judiciary in a specialist court drawn from a background that has lived the experience and the reality of successful, efficiently run private dispute resolution by way of arbitration. The litigation we then see arising out of or in support of arbitration, particularly arbitration in London and including arbitration on LMAA terms, obeys what might be called the iceberg principle of litigation. That is to say, it is both a lot of what we do and also hardly any of what happens. Let me unpack what I mean by that. We will be reporting in the next Commercial Court annual report, E and OE, as to whether these are completely audited and up-to-date figures, that for the most recent completed legal year, that runs 1st of October to 30th of September, so that's the year ended 30th September 2025, the Commercial Court received something just shy of 800 new claims, 30% of which related to arbitration. I don't have a specific figure for what I'm about to say, but the vast, vast majority of that 30% will have related to London-seated arbitration, but it will not be all London-seated arbitration, because we also have a certain amount of work that is in one form or other in support of arbitration seated elsewhere. So in that sense, it is a, by percentage, significant and important part of the court's work. But of course, translated into numbers of cases, it's a small, to mix my metaphors now, drop in the ocean compared to the volume of disputes that pass through the hands of LMAA and other arbitrators. Thus, to take as a for instance, we regard 2024-25 as having been a very busy year for new Section 69 claims at least being brought. 73 were brought. Well, you can all do the arithmetic. That's 73, and they won't all have been LMAA cases by any means. Even if it was all LMAA cases, that is whatever, 2% of the cases that have started out life as LMA arbitrations. When you in fact add in all the other species of arbitration out there, it's a tiny percentage that generates even an attempt to come to court and claim that arbitrators have erred in law, either on a point of sufficient importance or by a sufficiently obvious margin as to warrant an interference by the court to correct their decision as a matter of law. When one looks then at, as I know they can be, the scarier for arbitrators types of application about which perhaps they worry more, that is to say, applications suggesting that they have acted in the absence of jurisdiction or they have acted in some way procedurally irregularly, challenges under the English legal system under Section 67 or 68 of the Arbitration Act. Well, those between them only come to about the same number of claims made each year, and only a very small percentage of those succeed. And in many cases, if they succeed at all, they may only succeed in a particular or partial way, but which still results in a remission, particularly if it's a Section 68 claim, back to arbitrators, still ultimately to be in charge of the substantive decision. Alongside that, the other work that we see, which we regard as equally important in support of London arbitration, are applications under Section 44 of the Act in support of the arbitral proceedings themselves. So that is where, in one form or other, directions or mandatory powers that the court is in a position to exercise, but for one reason or other, the arbitral institution is not able to exercise, can be exercised so as to support and uphold the dispute resolution primary process in arbitration. That generates of the order of, again, a few dozen applications a year, the touchstone for deciding which, leaving aside, because it is a technical area, formal technical criteria as to whether we can act at all, will always be, are we being asked to order something that will further the interests of a proper, fair resolution of this dispute in arbitration? If we are, and it fits within the scheme of powers that we have to support, then we will exercise to support the process. If not, we will either not exercise or cut down the relief that is sought so that it is limited. And then secondly, and I think well known again to many in the room, but we will act in principle both rapidly and vigorously to enforce the underlying contractual obligation to arbitrate, or perhaps one should always say, strictly speaking, more accurately, the associated negative obligation not to do something other than arbitrate. That is to say, we will, in an appropriate case, act rapidly and vigorously to impose injunctions against those who would litigate otherwise than in accordance with their obligations to arbitrate. In all of those ways, against the background of, as I have suggested, history, experience, and the appropriate senior judicial personnel, we certainly see the relationship between the English court system and arbitration as an entirely constructive one in which we exist in partnership, and the court's only ever motivation or purpose is to support the arbitral process. Thank you very much.
Thank you very much, Andrew. I think it's really heartening to hear that, certainly from a user's perspective, that the judiciary are so experienced and steeped in arbitration. And I think we're particularly appreciative at the amount of support that the judiciary give to enforcing arbitration clauses in contracts. So thank you very much indeed. And talking about the user, I'm going to ask Chris a question. Chris, you are, as I said earlier, the ultimate user. What are you looking for in a dispute resolution clause? And maybe, I'm sure there are more than 3 or 4 points, so maybe just about 3 points.
Well, I think firstly, we're looking for a clause that enables efficient commencement of arbitration, doesn't put too many procedural hoops in the way. A clause that enables arbitration to be commenced in a straightforward manner without delay. I'm obviously coming at this from a perspective of a commercial entity. Usually, well, in fact, almost always with a commercial entity on the other side. So the parties have generally already explored meetings between the relevant people involved and tried to come to some arrangement. And if that's not possible, one party isn't happy with the state of affairs, that's when they want to commence arbitration. So to then be faced with a clause that mandates a lengthy or costly or cumbersome procedure before you can appoint arbitrators isn't particularly appealing. So I'd say that's one thing we're looking for in a clause. Secondly, again, coming at it from the perspective of a commercial entity, although in fact anybody would have probably the same view of cost effectiveness. To have a clause that provides for an arbitration process involving an enormous deposit up front, or mandating an arbitration procedure that is lengthy and complex for any size of dispute, I would say isn't always appropriate. And we very much appreciate clauses that have the ability to have a more streamlined process for lower value or less complex disputes. So I think that's the efficiency and cost effectiveness there. In fact, we've actually got a dispute at the moment where the amount in dispute is not small. We certainly don't want to be giving up on it, but the arbitration clause in question provides for a very complex form of arbitration, which will involve a large amount being put up front. And what we're finding is that that obstacle can then hinder the dispute resolution in itself. Either it's a case of delaying putting the money up, but eventually we have no choice but to do it. And then, of course, it's whether the parties become, let's say, more entrenched in their views because one party has invested a lot of time, cost, and effort in getting the arbitration underway. And I'm not personally convinced as to whether that's helpful for resolving the dispute. I think having those costly steps at the outset isn't conducive to getting a dispute resolved efficiently. And if we're talking about a third criterion, I would probably say, I don't want to say predictability of outcome, because I don't think that's probably the right way of phrasing it. But in terms of the knowledge that the tribunal will be formed of people who have experience and expertise in the subject matter. Clearly, a lot of arbitrations will relate to novel points of law or issues that haven't arisen before, because, of course, otherwise, quite often the parties you'd hope would be able to reach a conclusion themselves without going for arbitration. But I think it's that security of knowing that you have a tribunal of people that won't need to be guided, at least in terms of the actual understanding of the subject matter, and so that's also something we'd be looking for.
Thank you. I'm going to turn over to Will and to Clare. I'm just going to suggest the 3 headline points then that Chris has just said that users are looking for: efficiency, cost effectiveness, and a form of predictability of outcome in the context of the constitution of the tribunal. Do the LMAA terms deliver that?
So I was going to deal with the first 2 points, the efficiency, and in particular, as Chris was saying, the speed to get or the time it takes to get the arbitration up and running. Because if you're a claimant or you're acting for a claimant, what you really want is to get the other side to engage with your claim, and that will happen when they start preparing their defence. So the period between starting an arbitration and the other side or the respondent having to put in their defence, I think, is key to getting things moving. And I think the LMAA terms are very efficient on that front. You appoint your arbitrator. Normally, the other side has 14 days to appoint the second arbitrator. If you've got a three-person panel, then there's basically a month each for service of the claim submissions and the defence submissions. So you can basically get from starting the arbitration to the other side having to serve its defence within about 2 months, and that I think is very efficient, and that gets things going. Obviously, those times are subject to extension, and when I started doing LMAA arbitrations, it was predominantly on charter party disputes, but then gradually moved to more shipbuilding and marine construction work, and those arbitrations are more complex. And it's fair to say that the LMAA time periods are aimed more at probably the traditional smaller charter party disputes. But I still think that because you start from a relatively short time period of the 28 days in the terms, that you'll end up with something that's probably shorter than if the tribunal had a blank sheet of paper in the first place. So, and if you compare that with with, say, some of the institutional arbitrations, you have a lot more steps up front in between starting the arbitration and serving the defence. So you might have a terms reference, you've got the procedure for appointing the tribunal, which can take some time. And then quite often they have the procedural order before anyone has served, a proper submission. And that all takes time, and that all takes time up front. And I think for claimants, they can find that quite frustrating. So the second point I was going to just mention, which Chris raised, was on costs. So under the LMAA, I think it's again, I think it is very efficient. I think you get what you need and you pay for what you need, but you don't pay for more than you need. So you're just paying for the arbitrator's fees. You're not paying for institutional costs. There's a relatively small or a very small appointment fee under the LMAA terms, which I think is very is psychologically important for a claimant who wants to get things going, but might, as you say, be put off by a very large upfront payment. And then as you move forward, again, it is your fees are linked to the time that the tribunal spends. So you've got interim fees, you've got booking fees for the hearing, but they will generally be staggered. So you'll have to pay them in stages. So if you settle early, you still save quite a lot of money, and then you may have security for the tribunal for the hearing. And again, there's no institutional oversight of the fees, if that is what you may be concerned about. But again, you have the court standing behind the terms, and if, for example, there's a dispute about fees and the tribunal are holding on to the award until their fees are paid in full, you can apply to the court, and the court will order delivery of that award, but against a fee, which may not necessarily be the fee that the tribunal is asking for. So there is a degree of oversight which is essential. And I would say, just generally, that the LMAA terms, sit or provide a framework for the arbitration, and with the support of the court behind, that is really all you need, I think, for an efficient arbitration and an efficient way to resolve your dispute.
Well, I'm going to very briefly cover Chris's final point on predictability and quality of decision making. Essentially, it's the parties who choose their tribunal. So in a sense, they're the authors of their destiny. And it's a question of choice for the parties. Arbitrators aren't imposed on the parties generally under LMAA terms. So in a sense, the parties can choose an expert, whether it's a lawyer or somebody with technical expertise or commercial background, and all those backgrounds are valued. We would say we have a really strong pool of expertise in London. We would say that, but actually you can choose somebody not based in London. We do have a very wide range of people doing these cases. And as I say, it's up to the parties to choose somebody with the right expertise. Turning also, I'm going to be looking at efficiency and getting a dispute through to the end in an effective way, and particularly looking at aspects of offshore work as a particular area of focus. A lot of offshore disputes are large, but as Chris said, you can still get small disputes relating to offshore projects. And I think the LMAA small claims procedure is really useful as a tool to have in any contract, because it means if you've got a small dispute, you've got a small low-cost procedure where fees are capped, lawyers' costs are capped, and there's quite an expedited timetable, and no right of appeal. And so it's a good process where you can get a small dispute decided without shaking the cage of a relationship in the way that Chris was mentioning is potentially hazardous in an ongoing project. But returning to the bigger disputes, I'm just going to cover a few aspects. As I say, the offshore disputes may often give rise to large technical disputes, which may mean there's a lot of documents, fair amount of expert evidence, and a risk of high costs. And just look at a few areas where practice may differ in ad hoc cases. I'm talking about under LMAA terms, ad hoc cases, compared to maybe an institutional process. First of all, there is a debate in terms of statements of case, and do you go with pleadings or do you go with memorials? And this becomes sometimes a slightly cultural debate. There's a slightly tribal view of some people will feel very strongly that pleadings are the right thing, and others will say, well, memorials are the way you do international arbitration. I think in practice, often the difference between those methods is actually much smaller than people think. I mean, in LMAA terms, the default is statements of case followed by witness statements and expert evidence. But actually, the LMAA small claims procedure is a memorial procedure. So we do memorials in LMAA terms, but the starting point is within the rules is you have statements of case, but that's not inflexible. And if parties want memorials, they can ask for them, and tribunals can work with them. There are, and as I say, the difference is smaller in practice, because under LMAA terms, you have to put your supporting documents up front. So in a sense, parties have to put their cards on the table at quite an early stage, even in that pleadings process. One thing I don't think works well, and you do sometimes get asked, is parties will have pleadings but want memorial-style timetable with sort of 12 weeks between each set of pleadings. I have to say, I think you've got to avoid mixing and matching and having the worst of both worlds. But I think if you've got a hands-on tribunal, you can have the best of both worlds. Another area, the second area I'm briefly going to cover, is procedural timetables. As Will mentioned, in some of the institutional rules, you're mandated to have a case management conference at the beginning, and often at the start, the tribunal will produce a lengthy procedural timetable, a procedural order number 1, and a procedural timetable taking the matter to a hearing. In LMAA terms, the default position is you exchange statements of case and you only start talking about directions for evidence at the close of statements of case. Now, there are pros and cons to both approaches. In some situations, it may often be far too premature to be deciding when the hearing is and how long it should be right at the beginning, because you don't know what the case is about. But on the other hand, sometimes if you postpone setting a hearing until all the statements of case have been exchanged, you then lose availability to get a good hearing date to avoid delay further down the line. So again, it falls to the parties, their lawyers and the tribunal, to be quite proactive to ensure that you can tailor it to ensure you get a hearing at the right time without and the directions that are tailored to the dispute. And as I say, under LMAA terms, if both sides know they need a hearing, then you can ask for a hearing up front. And that may be, if you've got a large team of counsel, it may be appropriate to try and get things in the diary earlier rather than later. Third topic I'll cover briefly is expert evidence. And I think the LMAA terms favour a more critical approach to expert evidence, because deferring decisions on expert evidence until you've seen what the parties' cases are can be useful in narrowing the scope of expert evidence, because it forces parties to focus on identifying what the issues and questions are that the experts will be looking at, because otherwise there's a danger of just throwing an expert report in before the issues are identified, and that means that the experts' reports are unfocused and they're not really looking at what is in dispute. And the fourth and final point I was going to look at in terms of procedure and efficiency is document production. And here there's absolute flexibility. In a sense, there's not that much difference between institutional or ad hoc. Really, again, the parties are the authors of their own destiny, and they need to have a robust tribunal, because parties can cooperate and have efficient document production exercises, or the lawyers can generate a lot of costs. And in a sense, it's for the parties and the tribunal to ensure that costs don't escalate. So I think that, and red fern schedules, again, they're a common feature in LMAA arbitration. That there was a time when they were probably considered rather novel. Now they're very routine. So in a sense, there's not that much difference in practice in that area.
Thank you. We're going to pick up on one particular aspect of dispute resolution, and that's concurrency. It can be quite knotty. We're going to hear from Jess and Sean about that. The context will be offshore energy and offshore construction disputes. They tend to involve offshore construction projects tend to involve multi-party contracts, and they give rise to their own special issues. In the offshore sector, it's actually very rare to have one global contract that pulls together all the service providers. It tends to be disaggregated. So you have a range of different contracts with multi-parties who are providing different services, and they all interface with each other and give rise to their own special issues. So I'm going to ask Jess and Sean. We've heard the headline points, and sorry to repeat them again, but efficiency, cost efficiency, and predictability of outcome. Can we meet that with our terms in the offshore sector?
Thanks, Sarah. So exactly as you just said, in the world of offshore construction, and I'm coming at it more from the energy perspective, we are generally dealing with complex, high-value disputes. And when things go wrong, they tend to go really wrong, and they will have a high price tag attached to them. Add into that, again, as we've said, we're generally dealing with multiple parties, subcontractors, all with different work packages, all of which interface with each other in various different ways. So when it comes to the dispute resolution procedure, a key issue when we're looking at arbitration and the fact it's a contractual mechanism is the consistency of decision between the contracts. And obviously, depending on where you sit in the contractor chain will depend on how much of a concern that is for you. But the reality is that no doubt, despite the lawyer's best efforts, there may not be back-to-back dispute resolution procedures in all the contracts. But as and when everyone is considering the dispute resolution procedures and the rules or institutions that are going to be referenced, how the multi-party dispute side of things is dealt with is obviously very much a key consideration for us. And I think it's safe to say that over the years, the institutions have addressed the issues around, to the extent they can, around consolidation and joinder. And certainly that is generally what I see as and when these disputes arise. What I see less of is concurrency. And I think it's because, again, the contracts that I tend to deal with are looking more, or tend to reference more, the institutions rather than ad hoc. And it gets back a bit to this question around perceived certainty, where everyone tries to draft for all the likely eventualities. The downside of that, obviously, is that then you potentially don't have the flexibility you may ultimately need. So for me, concurrency does provide potentially a very interesting alternative in terms of the way of managing these disputes, because as and when, in particular with consolidation, in the world of construction, we are again, exactly as Claire said, there is a lot of expert evidence, factual evidence that will lead to typically more procedural steps and hearings. And it's very difficult where you've got parties who are potentially have a much smaller share in terms of the value of the dispute and general involvement in the arbitration. So there are certainly, I find, risks or issues with some parties having what is effectively a disproportionate involvement, exposure, however you want to look at it, in these multi-party arbitrations. And that's before you get to issues around the timing of the award, if they are potentially out of pocket. So I think there are still certainly a number of imperfections and issues around how these are dealt with in practice, albeit there's obviously been huge improvements with the provisions around joinder and consolidation. I think what the LMA rules do that feels different from what generally I see in other rules is this real flexibility around the concurrency, which seems to be a real opportunity for us to, certainly within the construction and the energy sphere, look at those more sort of provisions adopting the concurrency and the potentially addressing some of those issues where inevitably there are some inefficiencies in the consolidation processes that are typically adopted.
So picking up what Jess has just been saying about concurrency in the context of the LMAA arbitrations, it's worth remembering that one of the perceived disadvantages anyway of English arbitration, ad hoc arbitration, is that the starting point is that arbitrators will only have powers in respect of the particular arbitration reference in which they're appointed. So unlike Sir Andrew when he's sitting in his commercial court, where he can join in other parties in other disputes as he sees fit, an arbitrator in an ad hoc arbitration can only deal with the parties with which he has effectively a contractual relationship. So one of the significant advantages of incorporating the LMAA terms in a multi-party environment is that power to order concurrency. Paragraph 17b of the terms says that where two or more arbitrations appear to raise common issues of fact or law, the tribunals may direct that they shall be conducted, and where an oral hearing is directed, heard concurrently. So a pure ad hoc tribunal would not have that power. But I'm also going to suggest, as well as the LMA approach providing that power being an advantage over ad hoc arbitration or pure ad hoc arbitration, it's also more flexible and commercial in the way that that's used and included in the terms than some of the bigger arbitrations in two ways. First, that the decision is made by the tribunal rather than an institutional court. Again, that's not true of all the institutions, but it is of some of them. And that means, in my experience, that it is more commonly ordered in LMA cases and with much less fanfare. And the other advantage is that it's usual to order concurrency as opposed to full-blown consolidation. And that is a much lighter touch. It enables the two tribunals to hear parts of the case or manage parts of the case together, but they're not, the cases are not necessarily once and for all turned into one single arbitration. So let me give you two examples of that in practice, two recent examples of very different types of multi-party case. One was a high value dispute arising out of, to try and keep it all very general, a problem with the link between an accommodation unit and an offshore platform in the context of a big offshore project. There was a claim then passed up from the main contractor to the logistics provider to the owner of the accommodation unit. So those three parties were effectively all involved in this claim being passed along. That claim included a lot of wasted costs of disruption to the project as a result of this problem with the link. So both the charter of the accommodation unit, so the singular accommodation unit, and the whole arrangement involving the link and the platform, they were being chartered on supply time form. And therefore, both of the owners of those various bits of equipment wanted to argue that a significant part of the claims were excluded by the knock-for-knock provisions or the consequential loss provisions. There was an obvious benefit in both stages of that argument being heard at the same time. There were two different tribunals, but they all involved four ex-members of the Court of Appeal. And it was important that the tribunals were the ones who were able to make the decision on concurrency, because they could see that the issues overlapped, although they weren't the precise identical issues. There were different bits of wording in the two charter parties, but the starting point was the same. So that might have put off an institution looking at this. They might have looked and said, well, that doesn't look like it's the same wording, it's a different issue, therefore we won't order consolidation. But in practice, it was much more efficient to have a single hearing. There was actually a short hearing of about half a day of legal submissions across both arbitrations, which was much more efficient for all the parties involved. And then once that decision had been made, the two arbitrations were able to split off again for evidential hearings where the factual issues were much more discrepant. So they didn't have to stay together and hear all the issues together. So it was valuable that they were not consolidated and stuck together for once and for all. Another example, very different type of case, much more, you might say, right in the middle of the LMA's business profile, is an urgent arbitration I'm involved in with a ship owner and a charterer in one arbitration, and the same ship owner and the shipper in another arbitration, all arguing over a cargo that has been discharged but not yet delivered. And there again, it's easy to see that for the two panels, there's a great advantage in being able to move quickly to order concurrency, to manage those two different arbitrations together, and then decide the urgent issues about what's to be done with the cargo immediately in both of those different arbitrations. The expectation would be that will greatly speed things up and be much cheaper for the parties. But again, it may be that once those urgent issues are resolved, that the questions about damages, if there are any, don't need to be heard altogether and give rise to separate issues between the different contracts. So a high degree of flexibility is very useful for cases in the shipping and the energy sphere, because you often have these chains. You have chains of contractors and subcontractors in energy projects. You have chains of charter parties in the shipping world, chains of sales in commodities, and all of that can be addressed by using that power to order concurrency. And I'm going to finish because I was asked to provoke a little bit of discussion. So let me add one aspect where an order for concurrency doesn't change the rules, and that's where, in relation to awarding costs, there is a long-standing wrinkle in English arbitration that the arbitrator can only award the costs of that specific arbitration. And that's why in chain arbitrations, parties often end up claiming the costs of defending a claim up or down the chain as damages, as in the cases the Vacus T, you're probably all familiar with it. But that problem is not, if it's right to call it a problem, that feature is not solved or adjusted by the power to order concurrency. So a thought for when the LMAA terms is next reviewed, is there value in including a provision that the parties agree that if there's concurrency, then orders for costs could be made in the same way as if there was consolidation? Would that work? And more to the point, would users want that, or are they happy with the way it works at the moment? Sarra, back to you.
Sandra, did you want to say something?
Yes, I was just, if I might, I was going to take the liberty of coming in on the back of some of what Sean has said, at the possible risk of edging ever so close to no longer seeming so impartial as between LMAA terms and other species of popular arbitration methods. If there is a single, I would say, 21st century message for dispute resolution generally, it is bespoke flexibility in your judge or tribunal to be able to do their best to fit procedures to the particular dispute and not be hidebound or stuck to an entirely rigid way of doing things just because that often works and people are familiar with that, if in the particular instance it can be seen not to be either the fairest or the most cost-effective or a bit of both way of going about things. I would like to say, and would say, of course, wearing my hat as editor of the Commercial Court Guide, that for all its, in other respects, cumbersome nature, I would suggest that the current approach of the Civil Procedure Rules and the Commercial Court Guide for Commercial Court and Admiralty Court litigation probably does strike a good balance between having effectively a set of default procedures that, unless and until something different is ordered, will apply, and those practicing in the court will be familiar with them. But we know that we can do, within reason, almost whatever we want to fit the particular case. And I would suggest that for the reasons Sean has been given, the LMAA terms have always sought to inhabit that same space for arbitration. That is to say, to have a set of rules so that for many cases where there's nothing particular about them calling for a more bespoke approach to the case management, you can just follow through the default rules. They'll work very well. You'll have a fair procedure. You'll get a result reasonably efficiently and everyone is happy. But in the smallish minority of cases by number of cases, but they'll tend to be the ones that are very high value, very high complexity, and where there's more room to be a bit bespoke about it, the terms allow that bespoke approach, and you're not hidebound to only having a limited number of options. And I do think that's a good thing.
Resounding support for the LMAA terms there. Thank you. We're going to change tack. We're going to raise a topic that's quite controversial, and we'd really welcome input from the floor. That's you lot, by the way. And it's in the context of tribunals being proactive. Tribunals have a statutory, and where the LMAA terms are incorporated, contractual duty to resolve disputes quickly and efficiently. It starts at the very first provision in the Arbitration Acts. Section 1A says this: the object of arbitration is to obtain the fair resolution of disputes by an impartial tribunal without unnecessary delay or expense. That's mirrored in section 33, the duties of a tribunal. And there's a very similar provision in the LMAA terms themselves. Sir Andrew will probably correct me on this, but I was going to say that courts tend to be reactive. You don't have ready access to the parties, nor do you receive documents in real time, by which I mean pleadings, witness statements, experts' reports. Tribunals, on the other hand, do. We're just an email away from contacting the parties. We do receive all these documents in real time. And the question is whether we should be using the tools in our toolbox more or less than we currently do. And the tools I'm thinking of are things like bifurcation, preliminary issues, early disclosure, interim awards, security for costs, concurrency. So the question I want to pose is, do people think that tribunals should be proactive, that we should be initiating case management? Or are the users happier with a hands-off, laissez-faire attitude? And I wondered if there was anybody in the audience who wanted to argue for greater intervention. Any volunteers? I could ask it the opposite. Is there anyone in the audience who wants to argue laissez-faire? Tribunal, please, hands off. We know where you are. If we want you, we'll come to you. We'll come knocking on your door. Is there anybody who'd like to argue for that? If not, I'll turn it over to the panel, who I think have got... Oh, there's a gentleman standing who wants to say anything. No? You made the mistake of putting your head up.
Yeah, I mean, my previous experience in one of our cases, we've seen the tribunal being contested by one of the parties to protect the integrity of the proceedings. And this was a very important issue in that case. And here, perhaps the tribunal should take some steps in order to give comfort to the parties that, yes, this is a duty and they would need to comply with that.
So we have a voter...
adding some discussions on.
So we have a voter for tribunal intervention, I think. Is that what you're saying? Greater proactivity on the part of a tribunal.
Sarra, while the audience is plucking up its courage to pick a side and either express a view or at least advocate for a view, and of course I have to preface any such comment by saying I would then judge a particular instance on its individual merits if it ever came across my desk. But that said, for what it is worth, I cannot envisage the possibility of a successful challenge to arbitrators based without more on the fact that they had chosen to be a bit proactive or interventionist, or even that they had chosen to be proactive and interventionist more than the average. That without more, I would find it very difficult to imagine could ever be regarded as improper. It all depends on why they were doing that, what, as a result of doing so, they directed or invited the parties to consider by way of case management or other processes, and whether the overall result was a fair one, rather than some pre-existing notion that letting the parties get on with it is good, and intervening is therefore or being proactive is therefore bad.
Well, that's reassuring. Sean, I think you've got strong views. And if you hadn't before, you have now.
Well, now I'm in danger of finding myself on the opposite side from Sir Andrew, which is a very, very dangerous place indeed to be. I don't really disagree with anything that's been said about the potential or the importance in certain circumstances of proactivity. I think the only concern or the only thought that I've had is that often with LMA parties, you're dealing with LMA arbitrations, you're dealing with quite sophisticated users who know what they want, and as a result, they may certainly I take the view when I'm on a panel, if the parties are, for example, quiet while they're dealing with something, while they're talking to one another, it may not be of any great assistance to them for me to pop up and start demanding that they tell me what's going on. They might want to have a negotiation and without the distraction of the tribunal getting involved. And I think that is acceptable too. I suspect there's a balance to be struck between situations where the tribunal can help things, where the parties are not making progress because they're at loggerheads, and we can help them to see a different way or another way forward. Sarra was mentioning things like preliminary issues or whatever. It may be there are scenarios where the parties haven't seen that possibility and the tribunal ought to suggest it to them. But equally, my own view is if the parties together don't want a preliminary issue, it really shouldn't be the tribunal forcing one upon them. It's your arbitration. In a sense, you're the people who've decided to have an arbitration. You're the people who've decided to pay for these arbitrators to decide your dispute. You're entitled to have it within reason, the way you want it. So where there is disagreement, I do take the view that the tribunal should be getting involved. But where the parties agree, I tend to think we ought to sit back and let them get on with it.
So Sean, you're a hands-off man. Jess, you must have been frustrated on and off over the years with tribunals who interfere too much and those who don't do enough. Where do you stand on this?
I'm going to have a horrible... Thank you. I'm going to have a horrible sort of fudged up response to that, which is it does slightly depend on the parties and also the tribunal. I've certainly had what I'd say perhaps slightly over-enthusiastic tribunals. I think one thing, and it's a bit more of a sort of stepping back point, which is that where the courts probably will be seen as more interventionist, that is, I think, intended to try and ensure that we have slightly more cost-effective, shall we say, proceedings. So they're going to have an eye on that. I think there is potentially a risk with arbitration that, exactly as Sean said, it may be that the parties have happily agreed that they're going to go down a particular course or avenue, and that may not be the most sort of cost efficient, and that suits the parties. But I think there's probably as I say, a wider point, which is there's potentially the risk that, whereas I remember back in law school when you had the pros and cons of litigation and arbitration, litigation was typically seen as more expensive than arbitration. Obviously, things have moved on a lot since then. But I think there is a risk it could go the other way, as in, and so that's something I think we just need to be mindful of. I'm conscious also arbitrators are potentially in a difficult position because they can be concerned around sort of perceived bias if they're pushing one particular way that may be seen as less attractive for one party than the other. So sorry, a bit of a fudged in the middle somewhere.
Has anyone from the audience decided they'd like to participate? A hand. Oh, two hands. Whichever, it's fine.
I tend to agree with Sean that if the parties want to go relatively slowly, party autonomy is important in arbitration, and the tribunal should be cautious about pushing them. But I think there is sometimes a disappointment felt by parties when one of them wants to go quickly and the other wants to go slowly, and some tribunals seem to split the difference. Personally, I think that's usually a mistake, and the tribunals ought, unless there's good reason to the contrary, go at the speed of the party who wants to go faster, not least because, in my experience, the party who wants to go slowly is usually the party who thinks they're going to lose.
Or at the very least, Nicholas, treat it as an issue that should be resolved in one direction or the other. Either the tribunal is persuaded by the grounds being put forward by the party that wishes to go rapidly, that rapid is both fair and possible, and in that case, that's the decision, so be in that side's favour, or be not so persuaded, in which case potentially say, I'm sorry, I can see that you're very keen to get on with it, but I don't actually think that's fair in this instance, in which case don't potentially too readily order a timetable that's more rapid than the party that has actually won that argument was saying is sufficient.
Yeah, quite.
Robert, was your hand up?
Yes, I'm afraid so. There are big arguments for not being interventionist at the beginning. a great many cases settle at some point during the exchange of statements of case. And the parties are not going to thank the arbitrators for having read all the statements of case and formed a view. They just want the arbitrators to sit quiet while they get on with it. But I would suggest that when we get to the stage which in the LMAA is LMAA questionnaires, the tribunal should be willing to put other possibilities before the parties. What I'm concerned about is you can easily get a situation where a large case is being run by a partner and an assistant. The assistant does the routine thing because it's the only thing they feel safe doing, and the partner's basically concerned with client relations. The only person who's only going to think about how the case is going to be presented is counsel, and counsel hasn't been instructed yet. So there's something to be said at that stage for somebody to come in and say, how do you think this case is going to be presented? What issues actually matter? And force the parties and their lawyers not to just go chugging along in a routine way. From that point of view, I personally feel that the original version of this, when there was actually a meeting rather than just questionnaires on paper, had some advantages.
Well, it's true. The questionnaire is a milestone in an LMAA dispute. And that is indeed a golden opportunity for somebody, tribunal, to case manage from that point on. Is there anyone on the tribunal who would like to speak? Clare?
Well, only agreeing with you that in a sense at that point, I think the tribunal can be a little bit more proactive and not just wait for the parties to agree directions, actually look at what both sides are putting forward and get them to focus, as I say, for instance, on expert issues, prod them a little bit. You know, do you really need 4 sets of experts? Is that evidence going to be relevant? And also sometimes you have slightly less experienced parties. I had something that happens relatively frequently where parties, there are several disputes and they're talking about concurrency and they think that all the parties have to agree to it. And sometimes you have to sort of say, well, if you want concurrency, you can apply for it, because they sort of say, oh, somebody down the line won't agree to concurrency until they see X, Y, Z. And sometimes you do have to prompt the parties to get things moving.
Oh, Bruce.
Thank you. It seems to me that the answer to this is it all depends on so many factors that one can't really take a firm position one way or the other. But I would mention that there was once a wonderful arbitrator whose name was Ronnie Bernstein, and his motto was "Be bloody, bold, and resolute." And I think that's something that arbitrators generally, well, certainly LMAA arbitrators, I don't know about others, but LMAA arbitrators generally might bear in mind. A little bit more courage is needed, but always refer back to the Act. And whilst I'm speaking of the Act, may I mention that the Arbitration Act 1996, a commentary, an excellent work, is about to come out in its 6th edition, which you will be able to find in bookshops, I'm told, on the 10th of December and online sometime during this week. Thank you.
Hear, hear. Look, I'm going to wrap up, so we've got time for tea and biscuits. The only thing we haven't mentioned is AI. It's probably a good thing, but I thought you'd like to know. I asked AI, what do you think of the LMAA terms? And this is how AI answered. As an AI, I don't have personal opinions. However, the LMAA terms are widely regarded by legal and industry professionals as a highly effective, popular, and well-designed framework for resolving commercial maritime disputes, particularly in London. Well, personal opinion or not, I'm very happy with that. I've got some thank yous, a huge thank you to each and every member of our panel. You've all put a lot of time into this, and we're very, very grateful. And thank you, Sir Andrew, for making today happen. The IDRC and its team are fantastic. They are a can-do team. I don't know if there's any of them here in the room right now, but a big thank you. Margaretta, are you here still? I'm sorry I saw you. I keep saying this, but it's no exaggeration. Without you, there'd be no LMAA. So a big thank you. And finally, I know there's no one here from the London Arbitration Work Committee itself, but they've done a fantastic job this week. I mean, it's the inaugural law week. London have never hosted one before, and it's been a huge, well, there was a huge successful reception last night, and it's a really fantastically well-planned week. So although they're not here to get their thank you, I thank them as well. So thank you all very much indeed. Please stay, have a cup of tea, have some biscuits and a chat. Thank you.
Thank you, Sarra.
Thank you. Sure.